Mr. Hancock.
Good afternoon, Your Honors.
Good afternoon.
I'd like to reserve 2 minutes.
2 minutes? Yes. And I thought I might point out that the reason we moved this case to the end of the calendar was so that the Court might detain you all beyond 5:30 if it were necessary to answer all of the questions that were raised.
Thank you, Your Honor.
You're welcome.
May it please the Court, under the extraordinary ruling before this Court, the Governor now has the power to enact general legislation amending state laws without any approval or input from the legislature.
Specifically, what are you asking this Court to do?
Asking the Court to reverse the order below and to interpret Article 7 of the Constitution the way it should be interpreted, the way it is now, Your Honor, as interpreted by the decision now before this Court. And the Governor concedes this, that under this immense power, which the interpretation has given to the Governor could hypothetically attach to his appropriation for the retirement of state employees a proviso raising the state retirement age to 80. This is on page 54 of the Governor's brief in the Silver case.
And, Mr. Hancock, is this something brand new?
Yes, it is, Your Honor. Yes, this is the first time that any court has provided that the Governor can include in his appropriation bills general legislation amending state laws and then preclude the legislature from changing those general laws, amending state laws in any way. Or
is this the first time an effort has been made to do that?
I believe, Your Honor, that this is the first time that an effort has been made on the part of the Governor to actually attach general legislation amending state laws to the appropriation bills. This was not the case in Silver or in Tremaine 1 or Tremaine 2. And it wasn't the case in any of the other, excuse me, Your Honor.
I'm sorry, I didn't mean to interrupt you. Could you discuss Bankers Association case? How does this case differ from that case?
Bankers applied Section 4, but only to, in addition to an appropriation bill by the legislature. The fee provision was added by the legislature and very properly held to be a violation of Section 4 because it could not be the addition of an item of appropriation or a reduction of an item of appropriation. Bankers doesn't apply. It has nothing to do with the issue confronting the Court in this case, which is what the Governor can put in his appropriation bills.
Well, what would be the new rule now that you would want us to state in terms of what language is related to the appropriation and what is what you're calling general legislation? How do we define that distinction?
I think the answer to that, at least a very good starting point for the answer to that very good question, Your Honor, are two cases of this Court, Tremaine 1 and Tremaine 2. They both stand for the very logical proposition that what should go in an appropriation bill is what the legislature can do something about under Section 4. That is, items of appropriation which the legislature would be able to reduce or strike out as an item or add an item to. That's the holding, the crux of these two important cases, Tremaine 1 and Tremaine 2. Then Tremaine 2 goes on and states further that items of appropriation are to be the amount of the appropriation, who it's for, and its purpose.
Could you illustrate that against the example you gave us? I, too, noticed the governor's statement that the governor could propose an appropriation of retirement benefits for state employees and include a provision raising the retirement age to 80. That is the governor's position.
That's correct.
And
That is
now
the
exactly
governor's-
what's wrong with that?
Because that raising that state retirement age, hypothetically, would be amending the state law. A proviso attached to an item of or an appropriation bill changing the retirement age from whatever it is to 80 is not an item of appropriation, Your Honor.
Even if it's
That's
worded,
general legislation.
suppose the appropriation were worded to say we appropriate yea much money for the payment of pensions to people over 80. Can you do that? Is that an appropriation?
I would, certainly appropriating an amount of money would be, yes. A statement of the purpose to fund retirement, yes. And whether it could be further limited to, say, retirement for those who are over 80.
Some description of the recipients.
It would be some sort of a description of the purpose.
Let me ask you
But
this.
another, excuse me.
Well, isn't that what was done here in the example?
No, Your Honor, because what this does is to change the existing law in the hypothetical. Just the way, for example, what happened in this case. Appropriation for the state library and for the state museum. Attached to those appropriations was a proviso changing the law, amending the education law, and changing the museum and the library from the state education department and the Board of Regents to the newly formed Council of Cultural Resources.
Is that actually what the language said?
Yes.
Well, where is that?
Yes, attached to that. It is in our brief, Your Honor.
And when I looked at what I thought was the citation in your brief, there's language about what the council can do, but I didn't see that it actually reallocated the responsibility.
It doesn't reallocate anything, Your Honor. What it does is amend the education law so that that transfer takes place.
Does it do that? Does it do that does it say the education law is hereby amended, or does it simply?
Yes, Your Honor. And also, I should add to that one that that's a violation. This is probably beside the point, but it's a violation of the constitutional provision having to do with who can change the library and the State Museum, and that the Board of Regents can only make that.
So we're back to Judge Graffio's question, which I thought you began answering until I think I interrupted
I'm sorry,
you. About what can go into an appropriation bill?
What can go in an appropriation bill is, I think, very clearly stated in the two cases that I mentioned, Tremaine 2, which would be the purpose, who it's for, the amount, and then, Your Honor, very clearly, this court in Silver 1, the appeal that came to this court, has defined the other side of the issue, the other side of the coin, if you will, because it specifies what are non-appropriation matters. Specified that non-appropriation matters, which are to be submitted under Section 3 at the same time as the appropriation bills, contain programmatic measures such as suballocation, sources, schedules, that sort of thing, And I might add,
And those can be amended or altered.
yes, they could, exactly. They can be altered by the governor or by the
By the
legislature's non-appropriation bills. And significantly, Your Honor, further answering your question, in Silver, the companion case, which you'll hear next, the very kind of non-appropriation measures, sub-allocations, some amendments of existing statutes, 2 or 3 of them, the very, very kind of non-appropriation measures which the governor puts in his appropriation bills. In this case, the governor put in his appropriation bills in the 1998
Well, assuming
budget.
you're right, Mr. Hancock, and that you can imagine that the governor could, in an appropriation bill, put in naked numbers and nothing more, and then continuing along a spectrum, rewrite the entire civil service law, education law, or repeal the penal law in an appropriations. I mean, writers can do all those things, anywhere from 0 all the way to 100. So my question to you is why, assuming that some of these actions could be regarded as excessive, why isn't the ultimate answer that the legislature can tell the governor, I'm sorry, Governor, we're not going to go along with this, and that will generate the predictable negotiation that we expect in the political forum?
Well, 2 answers to that, Your Honor. First, the idea that the legislature's recourse is adequate to reject and say they're on the horns of a dilemma. Let's take the appropriation for state aid to school districts, $13.5 billion. The governor attached to his appropriation bill for the state aid for the school districts amendments of the state education law revising the way state aid is going to be distributed throughout the state. Now, take your recourse, the recourse that the governor says ought to satisfy the legislature is all right. They reject the whole thing. They reject $13.5 billion in state aid for education, and that's really no recourse at all because they can't do that. That's politically, practically impossible. Of course they can't do that. So really the negotiation is like negotiating with somebody when you don't have a gun and the other side has a gun.
Taking that example, though, they are altering the way in which state aid is distributed throughout the state. Why isn't that the proper function of an appropriation? Isn't that what an appropriation does, is provide where state aid goes in the state?
The appropriation, Your Honor, provides the money, but the distribution of the state aid throughout the school districts is a policy matter. That's a matter which is set forth in the education law.
Suppose an appropriation bill lists every district. It says, is hereby appropriated the following amounts to the following districts. District 1, yea, many dollars. District 2, yea, many dollars. That's an appropriation, isn't it?
The appropriation for state aid for education that we're talking about here is a $13.5 billion.
I understand, but I'm. But hypothetically, if it were done in that form, if you did it district by district and added up to $13.5 billion, it would be a proper appropriation bill?
I'm not sure that would, Your Honor. It would be a question of whether you can, and probably you could consider that itemization of the appropriation if it just went down that way. But the way the state the distribution is made is through the education law and through the formulae which are set forth in the education law. So that is
I understand that that's historically been true. Is there a principle that says it has to be done through the why is it done through the education law? Why can't it be done through an appropriation? How do we tell I guess I'm asking the same question we're all asking. What is the principle that distinguishes ordinary legislation from an appropriation?
I don't think it's ever been done that way, but hypothetically, let's assume that it could. It would be considered itemization of the appropriation. They broke it down into 500 or whatever amounts for each specific school district. I suppose that that would be considered itemization, and those would be appropriations.
Maybe you could help us by showing us in your appendix of the non-appropriation bills exactly what you mean. Maybe you can direct us to pages of your appendix and the actual budget, the actual bills that are here.
Or I'm holding the education appropriation in my hands, which is 16 printed pages. What is wrong with this, Mr. Hancock?
Because the 16 printed pages of added, those are formulae adding to the appropriation itself, matters which amend the state education law.
Is that what's critical, that there are sections of the education law
I
cited here?
believe that is critical, Your Honor. That's true.
How do you fit
And
that
also,
into,
but I would say,
Mr. Hancock, how do we fit into the concept of Saxon v. Carey, that itemization is kind of a flexible, elastic approach, and in some of these areas, there needs to be some description of the what, when, or how the appropriation is to be spent?
Saxon against Carey, as Your Honor just said, absolutely correctly, is about itemization. Saxon against Carey has to do with the degree of itemization in an appropriation bill, which is necessary for the legislative review, an appropriate review to do what they're allowed to do under Section 4, for example. So it's only itemization.
So the
which
budget can only contain that which Section 4 provides
That's the basic
legislative action?
That's the basic rule stated in Tremaine 1 and Tremaine 2, and it's perfectly logical because that's the way Article 7 is supposed to work.
What about Article 7, Section 6? Does that have no bearing on this at all?
I don't believe, Your Honor, our position, and our position is different from that which my colleague states on Section 6. I don't believe Section 6, the anti-rider provision in Section 6, has anything whatsoever to do with what the governor can put in an appropriation bill.
So you don't see that as a limitation?
No, I do not. I do not, because I don't think it
It's a
applies.
limitation to the legislature, but not to the
Yeah,
governor. Is that what you're
absolutely
saying?
correct. The anti-rider provision was added in 1894, Article 3, Section 22 of that Constitution, long before the governor could even submit appropriation bills. Then, when the governor was allowed for the first time to submit appropriation bills, a limited amount of legislative power, they didn't put the anti-rider provision
But it's in
the Constitution.
It's in Article 7 now, though.
They put it in 11 years later, in 1938, and
with a specific reference to a bill proposed by the governor.
well, it's debatable. I don't believe it does refer. I don't believe that the first part of Section 6 refers to bills submitted by the governor. I think Section 6, if you read it in the context of all of Article 7, you read it in the context of its history, and you read it in the overall scheme of Article 7, you come to the conclusion that the anti-rider provision is still what it always was.
But the first words of the section are, no provision shall be embraced in any appropriation bill submitted by the governor. How does that not apply to bills submitted by the governor?
If you read it that way, then you have the anomaly the end of that particular paragraph, Your Honor, and it makes that bill subject to the governor's veto. So there's an anomaly there. To be sure, there are other anomalies. I'm the first to admit that Section 6 is not the most clearly drawn section in Article 7, but the way that the governor reads it is that it is the sole limitation, anti-rider provision is the sole limitation on what he can put in an appropriation bill. It's even broader than its claim under the Saxon Perry. That means he can put anything in, anything, as long as it's
on the other
related.
side, on the other side of the coin, we understand what you're saying about conceivable excess. On the other side of the coin, if suppose the governor in an appropriation bill allocates $10 million for the creation of a cultural center in Chautauqua County, would the assembly, would the legislature then be free to write a non-appropriation bill saying, not a penny until we tell you when, where, and how that money should be spent and released?
Yes, I believe that would be perfectly proper. That would be one of the provisions enumerated in the footnote in silver, an authorization for payment by subsequent legislation. That would be proper.
Wouldn't that take the governor out of the?
I saw that.
Wouldn't that take the governor out of the process?
No.
Out of the when,
Any
where?
alteration?
Please do.
I must apologize.
You need not
I didn't
apologize.
see
That is,
that.
we left this additional time so that you could answer the court's question.
No, Your Honor, it would not, because the way it works is that would be a non-appropriation bill within the power of the legislature to enact under Article 3, Section 1, and the governor could veto it. The governor didn't like it, the governor can veto it. So that's the way it works. It's supposed to work.
In discussing remedy, you said that the legislature could not just reject what the governor did because politically they couldn't do that. But isn't it a question rather of what the Constitution requires, not what can politically fly?
Absolutely, Your Honor. You're quite right. And the Constitution would require that the governor put in his appropriation bills those things which should go in appropriation bills, things which the legislature would have been able to do something about under Section 4. So all I'm saying is that the governor's answer to the argument that I've been making all the way through is it really doesn't make any difference. I can put all this stuff in the appropriation bills. Sure, the legislature can't touch it under Section 4, but it doesn't make any difference. They can reject the whole thing, the $13.5 billion. So I say the argument about the practicality of it isn't anything to do with the way it should work. It's an answer to what the governor says is the way for the legislature to be able to exert its power. I don't think that makes sense because it's practically impossible.
Is there?
Go ahead, please.
I guess maybe I'm coming back to something, but can you state a test, a reasonably simple, definable test, which we can look at a piece of legislation and say that's an appropriation bill or that's not an appropriation?
Well, first of all, you look at Tremaine 1, Tremaine 2, and you look at what this court has described as non-appropriation bills, things that ought to go in non-appropriation bills and not in appropriation bills, and you make a judgment. It almost has to be case by case, then? Well, I think it's very, very hard to draw a hard and fast line, Your Honor, and I don't think the court has to do it in this case because the things that are in this case are general legislation Amending state laws, it's so far over the line that I don't think you have to. But if you have to draw a line, you've got the two Tremaine cases, you've got the description of non-appropriation bills in silver, and I think that's a good place to start.
Well, when you say good place to start, and Ms. Hancock, I'm not being facetious, but what you said sounds a little bit like, I'm not sure how to define it, but I know it when I see it. And that's why this is so elusive. We might be able to say, well, this one looks like it's above the line based on your test, this one below. But can you help us out? And we're going to ask the other side the same thing, at least I will, with words, rather than this one looks good, that one looks.
All right.
Can you help us out with wording a formulation?
I would say the basic proposition is a logical proposition, and it's stated in Tremaine 1, Tremaine 2, that is, what can go in an appropriation bill, it's the way it's supposed to work, is what the legislature has some control over under Section 4. And that's items of appropriation, which they can add to, an item to, strike an item from, or cross an item out. So that's what should be in there, something that which does not destroy the workability of Section 4, something that Section 4 can serve its purpose on.
Wouldn't that almost mean there could be no language descriptions?
It certainly states, Your Honor, that the language descriptions should be the way the governor did it in 1998. Those language descriptions were in non-appropriation bills. So, we really...
There have to be some words in an appropriation bill. You have to have something that says what the money's going for.
Well, here's
You don't want a budget submitted with only figures. How does the legislature determine how those sums are going to be expended?
Well, the legislature can suballocate. For example, let me give you an example, Your Honor, if I may. Take, in this case, the $17 million appropriation. Actually, I think it's an appropriation in the silver case, but that will work. $17 million to fund the STAR appropriation. That's relief for senior citizens
The real property tax.
from real property tax. That's all the appropriation said, $17 million. And then the
Could it say more?
legislature, in a non-appropriation bill, suballocated that, $13.5 million here and so on. And so that is an appropriation bill, and it had the purpose for STAR.
But the appropriation could have been further itemized. The appropriation could clearly have said 13.5 for this, 3 for this, $500,000 for that.
Probably so, because that would have been an itemization of the appropriation.
Could suppose the appropriation can say $20 million to build a prison in Syracuse, correct?
Yes.
Can it say $20 million to build a 180-bed prison in Syracuse?
Yes, I think so.
Can
Now,
it go on for pages describing the prison?
How far down you can go?
Exactly. How do we draw the line? That's what's driving us all.
I guess we're all asking the same question. We're all asking the very same question.
Once you put language in, and you're telling us we can't look whether it's specifically related and limited in its operation. I mean, that would be one way to do it, wouldn't it? To decide how much language was enough?
Well, if the court, and I certainly hope it does not, if the court should hold that the anti-rider provision, it can let the governor put anything in that's in any way related, that's anything.
Well,
that's the world.
No, it does say specifically related and limited, doesn't it, in its operation? It says specifically related and limited in its operation. It doesn't say just anything relevant.
But within specifically related, that's almost anything. It's hard to, I must say the governor, in his briefs, never tells us what the limit is as to what he could put in.
Perhaps Mr. Reese knows the limit.
All right. Thank you. I'm sorry it takes so long.
Not at all, Mr. Hancock. Thank you.
Mr. Reese, can I ask you to
So
look at
what-
one of these bills, or the bill that Judge Kay is holding in her hand, and just tell us what's wrong with it?
Your Honor, I want to do something totally different.
You want to talk about standing?
No, I don't, actually. I do want to talk about standing, and I do want to talk about legislative immunity, but I want to make something absolutely clear.
All right.
We view the approach to this whole issue fundamentally differently from the Senate, for exactly the reason the Court is struggling with. The Court is struggling with the line between what the governor can put in an appropriation bill and what the definition of that is. By the way, that's the line the Senate's position would ask the Court to draw, and it's the line the governor's position would ask the Court to draw. The Assembly's position is completely different, and it is based on the structure of the Constitution, and the Senate and the Assembly's position asks this question, not what the governor can put in or take out, because that is answered, Judge Reed, by Section 6. We believe that Section 6, as Judge Smith says, absolutely by its terms applies to the governor's appropriation bill. The question is, when the governor puts something in an appropriations bill that deals with policy issues that are fundamentally legislative judgments, what can the legislature do in response? That's the issue in this case. And Judge Smith, the question that you asked...
Are those when you say that are fundamentally legislative judgments, how are we... Is that limiting language? How do we know that it's fundamentally legislative judgment?
You don't have to decide that, Judge Smith, because under the Assembly's view, all you have to look at is whether the legislative responses are consistent with the Constitution. So you don't have to decide whether it's legislative. And by the way, it is clear from this Court's decisions, from Article 3, Section 1, and from the history of the Republic, going back to Madison and the Federalist cases, that policy decisions are fundamentally for the legislature. So when Judge Smith asks, well, what's wrong with putting the legislature to an up or down choice on an appropriation, what's wrong with that, Judge Smith, is that it makes the governor the arbiter of state policy. That is not the governor's job. It is the legislature's job.
What are you asking us to do then? What is the remedy?
Here's specifically what I'm asking the Court to do. First, the legislature has three options, all of which it exercised in this case when confronted with provisions in an appropriation bill that it does not like. One, if those provisions are larded into an appropriations bill, and the answer, Judge Kaye, to your question, is this the first time it's happened? I think there may have been one instance when Governor Cuomo did it, but no governor in the history of the state has done it as often as this governor. So when the legislature sees provisions implementing policy that it disagrees with, and there's 23 pages of provisions in an appropriation bill dictating how school funds get distributed, either the legislature, in our view, can strike those provisions as an item. If they're not an item subject to being stricken by the legislature in an appropriation bill as provided by Article 7, Section 4, then they are not an item for purposes of the governor's ability to strike them in non-appropriation bills. So either the legislature can strike those provisions in the appropriation bill because they are an item, or the legislature can pass other legislation, which is the term in Article 7, Section 3, the non-appropriations that change those policy choices, and the governor...
Suppose the legislature doesn't like the governor's whole budget, thinks the policy choices in the governor's budget are absolutely wrong, and it can substitute its own, write its own budget, and pass it as normal legislation.
No, but the legislature certainly has the option of striking out every appropriation the governor submitted. It does have that option.
It has that option, but does it have the option of enacting its own budget in its place?
In an extreme case, Your Honor, in an extreme case, Judge Smith, what the legislature would have to do, and this has never come to that, but Article 4, Section 6, gives the legislature the ability to propose single-purpose appropriation bills. So, yes, in theory, the legislature could strike the entire budget and issue a series of single.
But I guess I thought your argument was suggesting something else, that they can go outside the budgeting framework and they can pass programmatic legislation which rewrites every word except the numbers in the governor's budget, can't they?
They can pass non-appropriation bills which change the policy determination the governor has incorporated in the appropriation bills, in non-appropriation bills, and the governor then has the choice. On the whole, do I like the policy decisions the legislature has made? If I do, I won't veto the bill. If I don't, I will.
But what happened to executive budgeting? Haven't we just abolished it?
No, not at all, Judge Smith, because the fact of the matter is there is executive budgeting in 43 states in this country, and no governor in this country, not one, has the power the governor claims in this case. Not
Mr.
one.
Reese, and I was going to get to that very point. We sort of jumped right into the middle, and without starting at the beginning, which is the fact that we did go from a legislative budgeting scheme to an executive budgeting scheme. We went to that in 77 years ago.
We did, Your Honor. And what that means.
What does that mean, was the very question.
The constitutional history, Your Honor, Chief Judge Kaye, is absolutely clear. It means that the governor has primary responsibility for getting the information from the executive departments, paring down that information, collecting that information, and submitting a budget with numbers.
Only numbers?
No, the governor, and that's frankly the beauty of the Constitution. The governor can put in some language that he wants, but the fact of the matter is what the Constitution limits the legislature from doing is increasing those numbers unless they do it in a way that the governor can exercise his line item veto against.
And that's the only thing it prohibits them from doing? That is, they can change any word in the budget, as long as they don't change the numbers. But that is by non-appropriate, by ordinary legislation. Every word in the governor's budget is subject to change by the legislature.
I think in theory, yes. And then the governor has the choice whether to accept that or not.
So if he appropriates $1 million to a prison, and the legislature thinks it should be appropriated to the STAR program, it can strike the prison and write in the STAR program?
No, because that's for an entirely different purpose. The legislature can certainly strike the appropriation for the prison. It can then, in a separate single-purpose bill, pursuant to Article 7, Section 6, offer an appropriation.
That's not really what I'm asking. Can it pass the $1 million? It passes $1 million, and then for a prison, and then it says in substantive legislation, ordinary non-appropriation legislation, it passed a bill saying we refer to that $1 million for a prison. It's not for a prison anymore. It's for a ballpark. Can they do that?
Because, Judge Smith, in that case, I think it's pretty clear that that is an item of appropriation. It would have to be a single-purpose bill. They could do it in a separate single-purpose bill.
Okay.
So
What is the limit on what they can? Well, but I'm more concerned about what they can do in ordinary non-appropriation legislation. The single. I understand what you're saying about the single-purpose bills, but what is the limit of what they can do to the words in the governor's budget in ordinary legislation?
The limit is that they can't, in effect, make a new appropriation. They can't make a new appropriation except through a single-purpose bill.
And is there a way we can figure out whether they've made a new appropriation or just changed the old appropriation a little?
Well, I'll give you the first is the lawyer's answer in this case. There's nothing close to that in this case. Nothing remotely close to that in this case. And the second is, unlike the line that I think that the governor and the Senate would have this court try to draw, which I don't think is drawable in all honesty, that is something that everyone's going to know when they see it. If you take $1 million for the STAR program and you say it's for a stadium, everyone knows that's a new appropriation.
If it's that gross, but suppose it's for a prison and they say, well, it's for a prison in the next town.
Well, but I think that that's a legislative determination that the legislature is entitled to make in a non-appropriation.
So now you're saying that in my hypothetical where the governor has appropriated $10 million for a museum or cultural center in Chautauqua County, and the legislature passes a non-appropriations bill saying not a penny until we tell you what to do. Then they pass it and they say, no, this is going to Oneida County. Are they allowed to do that?
Well, I think there are two questions there, Judge Rosenblatt. One is the PTAC notion, this delaying of an appropriation until subsequent legislation is passed.
Well, that's what happened, right?
Yeah, and I think
so
that
let's suppose, can you just
yes.
be good enough to just direct yourself to this point? Now, if that was okay for them to do that, could they then, in subsequent legislation, say, not in Chautauqua County, this is going to Seneca County?
Yes, they could.
Well, if that's so, and this is what I find troublesome, then why haven't you just eliminated the governor from all determinations when the legislature then directs the flow of money, the what, where, and when of dispersals?
The short answer, Judge Rosenblatt, is that is the legislature's prerogative.
And the governor can veto it.
And the governor can veto it. You're
There is
absolutely right.
there is the one section of the Constitution we haven't talked about that I think is integral to the constitutional construct that we have, which is Section 2, that says the governor has to submit both the plan for expenditures and revenues. In discussing what's policy, it appears like policy is something that has no dollar amount associated with it. But where in the Constitution does the legislature have to respond to the revenue side of the equation? Isn't that what our constitutional structure requires, is that the governor submits a plan of expenditures and also a plan for how we're going to raise the revenue for it?
Absolutely, Judge Graffio. And the way the legislature responds to the revenue side is in the way it responds to all bills. That is, has the legislature, if there is a revenue bill, and it's not an appropriation bill, and I want to hold that because the appropriation bill is specifically defined and it means something very specific in the Constitution. The governor submits a revenue bill. The legislature has absolute plenary power under Article 3, Section 1 to amend that any way it wants. And the governor can then
I'm
veto it or
talking
not.
about the language that pertains to appropriations. You're suggesting that the legislative houses can develop its own language or policy statement, but those either program criteria or expenditures are going to have an impact. They're going to carry a dollar figure.
No, but that's the genius of the system, Judge Graffio. The legislatures aren't altering one penny of the revenues or of the expenditures. Not one penny. That's the genius of the system.
If they say subject to later legislation, they can address the dollar amount.
Well, but then the governor, if that's
You could say that for almost every item of the budget.
but Judge Graffio, the Constitution specifically contemplates that situation and says if the legislature is going to add another penny over what the governor has proposed in his appropriation bills, they have to do it in a single purpose bill that the governor can veto.
So what if they don't want to add pennies? They just want to take the pennies that he put in his bill and put them in other places. They're free to do that by ordinary non-appropriation legislation?
They are free to modify the policy decisions, the substance of an appropriation, until, Judge Smith, it becomes for something completely different. And then
Mr.
they
Reese.
might as well. And as a practical matter, Judge Smith, it's an interesting legal and academic question. But if the legislature doesn't want $1 million for the STAR program and they want $1 million for a stadium, they'll strike the appropriation for the STAR program and they'll have a single purpose bill for the stadium.
And Mr. Reese, how does the non-appropriation bill fit into Article 7 of the state constitution?
Well, I think that's an excellent question, Chief Judge Hayes. Article 7 of the state constitution, Article 7, Section 4, which is the veto provision for the governor, and Article 4, Section 7, Article 4, Section 7, the veto provision, and Article 7, Section 4, which are the no alteration clause, dovetail completely. What Article 7, Section 4 says is that if the legislature is going to have an additional appropriation, they have to do it in a separate single-purpose bill or in a separate provision in the appropriation bill that is subject under Article 4, Section 7 to the governor's line item veto. If the legislature chooses, pursuant to Article 7, Section 6, to make the additional appropriation in a single-purpose bill, the governor could veto that. The structure is elegant and it is brilliant. The structure says if the legislature wants to add another dime to the governor's spending, it can only do it in ways that the governor can veto directly. It either has to be a separate line in the appropriation bill, and Article 4, Section 7 gives the governor line item veto power over that, or it has to be done pursuant to Article 7, Section 6 in a single-purpose bill that the governor can veto. That is the genius, Judge Kaye, of the executive budget system. That's why we say every one of these issues is taken care of in the structure of the Constitution. And when you get to non-appropriation bills, when you get to bills that do not have, and Judge Smith, the question is, what is a non-appropriation bill? And a non-appropriation bill is a bill that does not have multiple items of appropriation. How do we know that? Because Article 7, Section 4 defines what an appropriation bill is.
As the question I was asking, Mr. Hancock, you're really saying we don't need to answer that. That is, we don't need to be able to recognize something that is an appropriation bill that is a non-appropriation bill in disguise.
I think that's a fair statement, Judge Smith. I really do. And let me just add one critical footnote here, and I apologize, but I know this is the critical case for the Court for running over my time. Our basic contention, one of our basic contentions, is that the line item veto, and this is really silver, but does not apply to non-appropriation bills. The other legislation under Article 4, Section 3, there is a critical reason why that is true. Article 7, Section 4, and it goes back to Chief Judge Kaye's question, was passed as part of the executive budget amendments in 1927. Okay? The provision that allowed the governor to submit other legislation that is now part of Article 7, Section 3 was not part of the Constitution until 1938. What does that mean? What it means is that it emphasizes that Article 7, Section 4, no alteration clause, means exactly what it says. Article 7, Section 4 limits the no alteration to appropriation bills, underlined 85 times. At the time Article 7, Section 4 was passed, the governor had no power, none, zero, to submit substantive legislation in connection with the budget. So Article 7, Section 4 could not apply to anything other than appropriations. It was only...
Let me be sure I understand what you're saying. You're saying that the no alteration clause means that they can't, that the bill submitted by the governor as an appropriation bill can't be amended before passage. It has to be passed without alteration. There can be reduction, there can be others, but there can't be an alteration. However, the legislature can, as soon as it's finished passing it, amend it by general legislation. It can alter it in that way.
Right.
And that doesn't that negate the rule that says the legislature may not alter an appropriation bill?
No, because there's a structural reason for that provision, Judge Smith. It is the very reason for the provision. And that structural reason is very simple. Under Article 7, Section 4, once an appropriation bill is passed by the legislature, it becomes law immediately. And if the legislature were allowed to alter an appropriation bill, it would never get gubernatorial review. Because under Article 7, Section 4, it immediately becomes law. And the reason the no alteration clause exists is to prevent the legislature from making legislative changes that the governor never has a chance to veto.
But of course, that problem, you wouldn't need the executive budgeting to solve that problem. What does executive budgeting accomplish?
Exactly.
How are we different? How is today's situation different from the old days of a legislative budget when the legislature could do what it wanted and the governor could veto?
Well, let me give you the simple answer, and then I'll give you the more detail. The simple answer is that the 43 states that have executive budgeting don't have the powers. The governor does not have the powers he's claiming here. But the more detailed answer is let executive budgeting accomplish exactly what the framers set out. One, it limits the ability of the legislature to increase expenditures except in situations where the governor specifically has the ability to strike those expenditures, either because the line item veto in appropriation bills or because they're single-purpose bills that he can veto. Second, it gives the governor the opportunity and the job of putting together the budget, gathering all the estimates, putting them in one place, sifting through them, and making the priorities.
Well, the President of the United States does that, too. But the United States doesn't have an executive budget system.
Well, that's true, Your Honor, but that doesn't mean, and obviously there are very different structures in the executive budget, and the federal government. The federal president doesn't have.
Well, I guess what I'm getting at is this: so, reading the two constitutions, you would think that the governor has a larger role in the budget process, and is intended to have a larger role than the president does in the federal budget process. On your reading, how is that true?
Well, because I think, Judge Smith, you have to understand where the executive budget came from. It came from an era in which the legislature put together the budget. Legislature didn't have the staff. It didn't have the ability. It was dependent upon estimates from the executive departments, which historically were wildly inflated. Legislature had no ability to go beyond those estimates, and it somehow had to cobble together a budget based on that process. And what the executive budgeting said is, that makes no sense. we've got to invest one person, the governor, with the responsibility of pulling all that stuff together, getting legitimate estimates from the department, making priorities, and getting a unified budget that the legislature can act on. So the answer, Judge Smith, to your question is the executive budgeting amendments accomplished a lot. But here's what they didn't accomplish. They did not alter the fundamental balance of powers in the state between the executive, legislative, and judicial branches. And that's what the governor claims they did. They did not. And the legislative history of the Article 7 makes absolutely clear that it did not intend to infringe on the legislature's basic prerogatives to set policy in the state. And that's the governor's position. The governor's position is totally unvarnished with respect to appropriations. He not only has the last word, he has the only word.
Could you once again tell us what you want this court to do specifically?
Yes, Judge Smith. I would like this court to reverse the judgment of the Third Department and to declare that each of the three actions that the legislature took with respect to the governor's 2001 budget bills were consistent with the Constitution. And I should add a huge footnote, because it's not, if the court reaches decision in this case. I haven't addressed it all, frankly. But let me finish my answer, Judge Smith, to your question. And those three mechanisms that the legislature employed was, one, to strike out items, and our view is those policy considerations in the appropriation bills constitute items, to strike the items out. Alternatively, the legislature was permitted, as Article 7, Section 6 provides, to pass single-purpose appropriation bills, which it did. It passed 37 of them, all of which the governor signed. Or three, the legislature was completely within its rights, pursuant to Article 7, Section 3, in passing and amending the other legislation in connection with the governor's budget, and that its actions in modifying the terms and conditions proposed by the governor in its appropriation bills in its Article 7, Section 3 other legislation were constitutional. So that is what we would like the court to declare. I
ask you this question.
Sure.
In Judge Malone's decision, I understood you to say that he accorded more relief than the governor had asked for you for. Can you elaborate on what you meant by that and what he did
yes.
to
Judge
justify your assertion?
Justice Malone, I believe, declared all the bills, all 46 bills, unconstitutional. I don't think even the governor asked that request to be done. And here is where I think the rub comes.
That's what he did. Now,
yes.
Why is that? You say that's more than they asked for?
Yes, because here's why, Your Honor. In striking some of the, actually, that's Silver. I don't believe the governor asked that all those bills be declared unconstitutional. I think he's challenged various legislative actions. I was about to lapse over into Silver, the Silver facts, and the reason why it's more than the governor would have wanted in that case is because the governor claims that every time the legislature modifies one of his appropriations in an Article 7, Section 3 non-appropriation bill, that modification is unconstitutional ab initio. But clearly there were a number of those, and we'll talk about this in Silver, that the governor liked and didn't veto.
So he declared all 46 unconstitutional. He was affirmed. So I just want to see procedurally the scope of what an affirmance by the Third Department connotes, because if they affirmed, which they did straight up, it means that ultimately the appellate division went along with granting the governor more than the governor had asked for. And that's what I'm pressing. And if you want to think about that later,
I do,
come back
Judge,
later, that's okay. We're not in any.
Thank you.
We're not in an emergency here.
The one thing I would note, Judge Rosenblatt, is that in some sense, because the appropriations are only for 2 years, and in some sense there's a question, it's a practical matter, these things have no effect anymore anyway because the appropriations have all in effect lapsed. Obviously, the constitutional issues remain capable of repetition, yet evading review. If I could, with the Court's permission, just save 2 or 3 minutes to address what I think are
Certainly, Mr. Reese. Mr. Hancock had reserved 2 minutes as well, so why don't we
Yes.
hear from Mr. Schechtman?
May it please the Court.
Good afternoon.
Let me start out by saying this. I heard Mr. Reese say that, and I quote, "the structure is elegant and brilliant." And I take it he's of that view because the structure that he described is legislative budgeting. He also says that there are 43 states that have executive budgeting, and none of them claim what is claimed here. I don't claim to be an expert on the other 43 states. I've struggled enough to learn Article 7. What I do think is the case is that the other budgets, that the other states don't have a no alteration clause. And we owe that to Henry Stimson and his colleagues, and that makes things very different. And what Mr. Reese wants to do is to eliminate the no alteration clause. And what I want to try to do for my first minute and a half, if I could, is take up Judge Saparek's question of pointing to a specific appropriation and telling you how the governor sees this working. And Judge Saparek, I'm going to cause you trouble because the one I picked early this morning is in the record, but it's not in your appendix. But it's simple enough that I think it works. It is an appropriation. It's in the record. It's 690 if you want to pick it up. And it is Department of Health budget. It is for grants for AIDS prevention and education to community-based organizations. And it says, for the purposes of this program, eligible organizations must, 1, operate in a neighborhood area with high concentration of risk population, and 2, provide services and programs that are culturally sensitive. Okay, and it's $12 million. So simply what we have is $12 million to local organizations for AIDS services on 2 conditions. 1, that the Department of Health give the money to neighborhoods that are high-risk neighborhoods, and 2, that it gives it to programs that are culturally sensitive. Okay. Now, I take it the Senate's position here is that that is not an item of appropriation. And I say this respectfully, but I think the Senate's position is it's because it has more than 10 words in it, that it has some terms and conditions, right? And that can't be right. I mean, that is, if I had stopped any of you in the hall and said, is that an item of appropriation, I think the response would have been, that's an item of appropriation. It sets out money, it has purposes, and it qualifies what they're going to in perfectly sensible ways. Now we
there are some things in there which, if you stopped someone in the hall and said, is that an item of appropriation, he would have been in somewhat more doubt, correct?
You mean in other parts of the budget?
Yes.
I'm not sure, Your Honor. I mean,
what about the school finance thing that goes on for all these pages?
It goes on for a lot of pages, but when you break it up, it's 16 pages. I mean, we have one from Governor Cuomo that I think is 8. But when you break it up, it is, for example, the Student Improvement Program, 1 page, and it sets out the eligibility criteria. So I think if you look at them individually, they really are appropriation. But stay with me for a second, if you would. Okay? The question is there any limit on what he can do? And that's a serious question, obviously. And the answer to that, I think, is the answer that Judge Reed suggested in a question, and that is the limit is in the Constitution. The limit is Section 6. And it's not a trivial limit. What it says is it has to relate to the item. Now, I have to say I'm not sure that has great force because it's a relevant.
So everyone would take almost a referee. I mean, the case you picked is easier than others that can be hypothesized so that we can test in theory what the limits are, because this is a declaratory judgment. And if the governor is intent on dealing with prison overcrowding, let us say, it seems to me that a direct way, relevant and direct way to eliminate prison overcrowding, I don't mean to be facetious, is to abolish the penal law.
Yeah. No, I agree with you.
So now where can the governor, because it is direct and related directly to, we want to, number one, put up 1 prison in X county,
right.
Secondly, abolish the penal law. It meets the test, I would think.
I don't think so, Judge.
You don't think? All right. Because it's absurd or what?
No, not at all in the sense that it's absurd. I mean, I think it is a very relevant hypothetical, but I'm going to if you stay with me for a second, I think I'll get there. Say you added a provision to mine. Mine has two at the moment: high-risk neighborhoods, culturally sensitive. Right? You could say, and to AIDS patients who are taking a certain mix of drugs. To my mind, that is maybe terrible policy, right? But to my mind, it is still a provision that relates and is limited in operation. If you then went on to say, and all patients in the state, all aid patients in the state, must take this mix of drugs, you're no longer limited in operation to the appropriation. You have gone beyond the appropriation. Right? So it's really not a trivial requirement.
Translating that to Judge Rosenblatt's hypothetical, you couldn't say the penal law is hereby abolished.
Exactly.
But you could say no funds appropriated in this budget shall be used to incarcerate anyone convicted after the effective date of the act.
Your Honor, I'm not sure that you could, because I think any of these penal law provisions, any time you're trying to amend the penal law in the corrections budget, you're beyond the appropriation. I have to.
How do we know that?
Well, look, take an appropriation that says so much for courts, and the following rules of evidence apply. Mm-hmm. Right? Seems to me that is beyond the operation.
Well, I guess I've said it seems that way to me too, which means there must be a line somewhere.
Well,
We're asking both sides what the line is.
The line is simply, is this limited to this appropriation of money?
And in your hypothetical, Mr. Schechtman, if that mix of drugs reduced the AIDS population, then it would be specifically related and it would be an item of...
In my hypothetical, Your Honor, if I
said... just staying with it.
No, exactly. In my hypothetical, if I said, right, that this money can only go to programs that use this mix of drugs, right, then I am limited in operation to the appropriation. But as soon as I say, and across the state, whether you're in this program or any other program, you must use this mix of drugs, then I'm proposing general legislation.
But what is the principle then?
Well, but that seems to me to be, that seems to me to be a principle that says you can attach conditions to this money that shows where this money can go. But as soon as you try to attach something here that reaches something else other than where this money can go, you run afoul of Section 10.
Well, then go back to the hypothetical. You could say, as to every prison in the state for which you appropriate funds, you could say it cannot be used to incarcerate anyone convicted after tomorrow. That would be limited in its operation to the appropriation, correct?
I suppose that's right.
So you couldn't abolish the penal law, but you could create a situation where you might as well have no penal law.
I suppose that's right. And look, I guess the answer is one can always create horribles that in a certain sense prove too much, because we're not close to that anything here. If you take this bill and if you go through it, what you will find is each one of these provisions say how this money can be spent. So you look at the improving student performance grants. They set eligibility criteria for how that money can be spent, right?
And where does this leave the legislature, which is under the Constitution, the policymaker?
Now we get to the next question, right, which is what can the legislature do? If I'm right that what I've described in the example that Judge Pataki asked me for, if I'm right that that is an item of appropriation, money to local governments, right, for AIDS, conditioned on two conditions, right, one of which is that they be in high-risk neighborhoods, two is they be culturally sensitive. The question then becomes, can the legislature go into that bill and strike the provision that says high-risk neighborhood? Can they do that? On the view that let's spread this around the state. Right? Why should we focus this on particular neighborhoods? I think the answer to that is clear. They can't. I think the Assembly agrees with that. I think the Assembly agrees that this is an item, and I think the Assembly agrees that the no alteration clause prevents that from being done.
But they say they can do it the next morning in another bill.
I think they can do it probably the same day. It's just later in the day.
Mm-hmm.
But
and I take it, at that point, you part company from the Assembly.
That's where we part company, because it seems to me, if you say what the no alteration clause says is you can't go in and make that change. Now, I take it that that's what bankers teach us, right? Because What Bankers says is they can't go in and add a condition. There they wanted to add an audit fee. If they can't add, it's not at all clear to me why they should be able to subtract. This is an item of appropriation, and the no alteration clause says they can't alter it. So then the next question in this case, right? So if I'm right so far, the notion is an item of appropriation, right, is money for a purpose limited by Section 6. Right? It's not a perfect test. There's a wonderful language in Tremaine that says just because you can state the test doesn't mean it'll always be applied. But
And how do you apply it now to the 16 pages of the education bill?
I would say
which contains many references to statutory
right, I would say that
sections.
every single one of those, Your Honor, passes the test of Section 6, which is the only test. Right? And let me talk about
Is it true that it has never been done that way before? The governor did put into his appropriations bills things that had always been done in separate legislation previously.
I notice you cited one provision from Governor
I cited
Cuomo's.
one-
I take it if you found more, you would have cited them.
No, Your Honor,
There are more?
There are more. Even there, I felt bad because it's a very long footnote.
No.
But
No,
so I
you
didn't
have
want to give you
longer
all. I didn't want to give you all
footnotes.
6 pages of it. But you get the sense that this is not the first governor who has conditioned items of appropriation. And Judge Smith, let me give you what is my favorite example from my time in Albany. There is a provision in the corrections law about state-ready prisoners. Those are people who have been convicted and are in local jails awaiting transportation to our state prison. Sometimes they're just waiting for the probation report to be completed. State law says $40 a day for those prisoners is paid to the local sheriff. For the last 12 years, we have not withstood state law and said $34 a day.
In the appropriation bills?
In the appropriation bills, right? I think it started because no one wanted to say to the sheriffs, we're going to go in and change existing law, right? Because that was a constituency no one wanted to take on in that fashion. So we said, just this year, we're having problems. We're going to not withstand state law and give you $34. Just this year has lasted for more than a decade, right? And I suppose on the sheriff's part, hope springs eternal. Someday we will spring back to existing law. But there's a perfect, long-standing example, in my view, entirely proper, in which one has a body of existing law and one notwithstands it, right, for budgetary purposes. It is, again, is it permissible? For me, there's only one test, which is Section 6.
Is that a little different because there's a body of existing law that specifically indicates an amount of appropriation as opposed to a body of substantive existing law?
Let's say we had an education provision that said, here's our distribution formula for improving student reading grants. And this year, it is a difficult year in terms of the budget. And so the governor says, I want to direct that money more. I don't want it to go to every school in the state. I want it to go to schools in the state that have reading difficulties. Now, remember, when we started all this, what Henry Stimson said is, he's the fiscal policymaker. You should stay awake at night and think about these issues. And so you say he notwithstands existing law, not as to the amount, as in my example, but he notwithstands it as to the eligibility criteria. The question is, why not? There's nothing, we've never said, this court, right, no other court that I know of has ever said that if there is existing law, it's binding on the future. We've never said he's imprisoned in the past. So the question is, why can't he go into that budget bill, notwithstand existing law, and change the criteria?
Mr. Schechtman, I just want to be sure I understand the test. It's any appropriation, an amount appropriated by the executive becomes an appropriation bill. It can contain, in your view, the where, the how, the when.
Any of the conditions.
Any of the conditions, and also anything that relates specifically to the appropriate. That is your test?
No. The second part of that is, I think, in many ways more important, Your Honor, because the second part prevents, except for the wonderful hypothetical, the second part prevents you from amending the penal law generally. The second part prevents you from passing general legislation. So if I said $500,000 for police cars and all police cars with this money must have video cameras in them. Right? My view, the governor's view, an appropriation. Right? How do you test it? It's money. It's for a purpose. You go to Section 6. You say it relates to and it's limited in its operation to that appropriation.
Now, if the legislature disagrees with that condition, do they have any recourse?
They have the following recourse. They can strike it, in which case one has
The entire appropriation?
The entire appropriation.
But your posture is not the condition for the cameras in the police cars.
Not-
They have to eliminate the entire
Because-
appropriation?
Yes, Your Honor, because that is what the non-alteration clause says. It says I can't go into this appropriation, right, and say to all districts in the state where it says high risk. It can't say I go into this and pull out the cameras from the cars. Now, mind you, if that appropriation said, and all cars in the state must be fixed with cameras, that runs afoul of Section 6. Because
I understand that point. I just want to know what your
my
position is with
my
regard to
position
what
is-
alternatives
my
the
position is
legislature
if
has.
those conditions are permissible under Section 6, and as far as I can tell, that's the only limitation. If they're permissible, then the no alteration clause says you can't go in and alter them. Now,
And the one limitation is, could you state it again? The one limitation is a general,
the one limitation is the limitation in Section 6, which is to say, I don't think this Court has to create it out of whole cloth because I think it's in the Constitution. It must relate and it must be limited in operation. And that latter part,
limited to the appropriation, though.
limited to the appropriation.
All right, so if that's
Well,
the
that's
case,
not hard to conceive, though, if,
It's not hard to conceive, which is to say,
no, I mean, it includes everything that
No,
could
it doesn't.
conceively relate to the,
No.
to the item of
Because when I
appropriation.
passed that bill, when I put in there, right, $500,000 for police cars, right, and all police cars in the state, not just the 200 under that for the 500, but all police cars in the state, right, have to have video cameras in them. I'm no longer limited to the appropriation.
What if your appropriation for police departments in the state says none of it goes to any department that's operating with any cars without video cameras? Can you do that?
Question, Judge. Yes, I think I probably could. Because
I guess the point I'm making is the power that your reading gives to the governor is potentially very. I mean, I guess it's a cliche. The power of the purse is enormous. I mean, there's very few goals you can't accomplish if you have control over the purse strings. Correct?
Well, look, I think there are a great many goals you can accomplish because I do think Section 6 has broad force. I mean, I think about all sorts of. If you were to go and look at the laws that were passed last term and say, can you find some way to get them into an appropriation bill? I suppose if you work hard enough, you might be able to find some way. But in the normal course, in things that we understand to be the case, you can't get them into an appropriation. You can't shoehorn them in.
I mean, it strikes me as the arguments on both sides wind up saying the same thing. Yes, you can think of extreme cases that would be ridiculous, but it's not this case.
Well,
is there any way to draw a line that separates the ridiculous from the non-ridiculous?
I think the answer is yes, it is Section 6 and one other thing, right, which goes back to the Chief Judge's case. Okay. What happens if something that is put in passes the test of Section 6? Now, there are times when Judge Hancock says it becomes law, right? The governor writes the law. But, of course, that's not the case. The answer is the legislature can strike it, and it does not become law.
But then the whole thing goes down.
The whole thing goes down, and there is discussion and negotiation. And that's what Article 6, that's what Article 7 says, Your Honor. There's only one other alternative, and that's Mr. Reese's alternative. Right? Mr. Reese's alternative is, I think he agrees with me. He may not, I think he agrees with me that the only constraint is Section 6. He may.
The only restraint what the governor can put in, not on what the legislature can take
That's
out.
right. I think he agrees with that. He may think some of my answers to your questions are wrong. If I go home tonight, I may think some of the answers.
Well, you don't care
are
for all of
wrong.
his answers either, right?
But where we differ is, and I think he thinks you can't alter him in the appropriation bill. Where we differ is he thinks you can go into that non-appropriation bill and rewrite what I gave to Judge Parrick as an example, and say, but not to districts that have high-risk populations, to all districts across the state equally. And his
That's
answer
because you're
is,
dealing with a statewide situation, and it doesn't pass your test of immediate relevancy to the legislation at issue. So I can appreciate that point where you're saying, once you make it statewide, you go beyond the immediate appropriation involved. Suppose we're dealing with a singular appropriation dealing with the construction of a building, which the governor thinks, maybe for good reason, is too difficult to build as long as the WICS Act is going to be required. So the governor says, on this building and this building alone, we're going to suspend the WICS law, or Section 240 of the labor law.
I think he can do it, Your Honor.
Well, that causes
In an
that's trouble.
appropriation bill?
So now, all right, we're now reaching the point where...
It is not, I'm suspending it across the board.
No, that's right, he's not. He says, in this instance, building costs are so expensive that we're going to do away with WICS for this building, and we're going to suspend 240 of the labor law. In this building alone, everywhere else it does. Now, that you will grant smacks of legislation.
I think all budgeting smacks of legislation, which is to say, what we know is that the executive budget allowed him to introduce legislation. So I think what I've read at the outset here, to me, smacks of legislation, which is to say the very notion that it should go to politically, culturally sensitive programs.
So the non-operation clause would be operative so as to bar the legislature from striking the provision that abolishes the WICS law.
If I'm right in my first premise, and
Right.
look, a court may tell me I'm not, right?
Right.
I mean, it's my
You've got to withstand all these various hypotheticals along the way.
Right. But I think at least we're asking the right question, which is the only question I can find in the Constitution, which is it related, is it limited in its operation? If we ask that question, and the answer is it's okay to be in there, right, then the question is, can they take it out? I think there's agreement with the Assembly that they can't take it out in the appropriation, right? That would violate bankers, that would violate Tremaine. Their view is they can take it out in a non-appropriation bill, right, or they can strike it out completely and pass, right, a single appropriation. Right. Judge, let me give you one example of where it leads. Tremaine 2, right? You will recall that had itemization for the highways, and then itemization was gone, I think is how the third department put it, and we had a lump sum. And the answer was that altered the appropriation. Right? They went right into the appropriation bill and altered it. Now, assume they did the following instead. They struck it. Then they passed a single-purpose appropriation bill for highways. It simply was lump sum. Now, that's doing indirectly exactly what we were told in Tremaine 2 they couldn't do directly. In other words, they couldn't convert those itemized to lump sum. The question is, can you do it if you're smart enough? We've gotten smarter since 1939. Can you do it if you simply take a single-purpose bill and do it? The answer is yes. I would think the answer is no. Otherwise, you don't have a no alteration clause, and otherwise you have
Theory,
a
that makes
legislative
sense.
budget.
The theory makes sense, and I appreciate that, but I just, forgive me for pressing this point to see just where it takes us as a matter of logic and practicality. You're saying that the governor could...
I should say I'm not entirely, I'm happy, I'm not sure I want to be where you're taking me, but they're hard
Well, I just want to see where it leads, and if you can abolish...
Hard.
All right. And if you can abolish the WICS law for that particular job and abolish 240 of the labor law, I'm just going to keep pressing this. Forgive me for doing that.
No, it's the opposite.
Can you also abolish racial segregation and the minimum wage?
I think the answer to racial segregation is easy, right? I mean, whatever else is true, there are other provisions in the Constitution, right? Which is to say, there is an equal protection clause and the like. So you clearly can't go.
Even just for this job,
No.
not every other job. It's just on this job alone.
Doesn't matter. I mean,
You're not saying you can amend the Constitution. You can
Right.
amend any statute.
Right. You can amend the statute. You
All
can't-
right, abolish the
you can't-
minimum wage. Let's leave it
you
with the
can't
minimum
notwithstand
wage.
equal protection.
Minimum wage. Let's take discrimination out.
Look, I think the answer is you could probably go in and notwithstand it, right? I mean,
You could also let them use cocaine on that job, not find the penal law.
People,
You know, the problem
It's still in-
well, with his hypotheticals, I don't do as well over here.
But still, we're still in
But
an
I
appropriation.
suppose the answer to that is if you said that there's some, I mean, look.
It's still an appropriation bill, Mr. Schechtman?
I think if.
I didn't mean to interrupt your answer, but
I thank you for doing it. Your Honor, I think the answer is that if there was a special reason that that job had to be done quickly, right? And if you said there's certain, as a general rule, there are certain rules about hours in the day, right? The governor could propose in an appropriation bill to notwithstand those. Now, mind you, that doesn't mean it becomes law.
And what about if it were several buildings scattered across the state, but identifiable buildings?
I think that you have the power to do that.
The governor could still suspend the wage and hour bill.
I think for purposes of that building in that appropriation, the governor, now, Your Honor's question always says the governor could do it. Remember, the question is the governor could propose it. Because the answer is if the legislature's view is can't be done, right, we won't go along with it, it dies.
Oh, but the legislature then has to strike the entire bill
That's right.
for all of this building all across the state. It can't just strike the provision that...
And say to the governor, right, it is your choice. If you want to go to the voters, say to the voters there's no building because you insisted on having this be 10-hour days. That's for you.
But that's very extreme to say the only remedy is to go to the voters.
But Your Honor, the hypotheticals that I'm getting are extreme, right? They all fall in the category of parade of horribles. Nothing in this bill comes close to that. I mean, look what's in this bill. What's in this
But we're
bill?
just testing the proposition.
No, I understand completely, but one should be careful in doing it. Because if you, look, I don't mean to push this point on you, but if there is a restraint other than Section 6, I don't know what it is.
That is not you said it's political. That is the...
Well, other than the political process.
Yeah, I mean, the governor might start worrying about his reelection if he's abolishing the minimum wage.
Or cocaine on the job site. I sense that he's opposed to. But if there is any other restriction on what he can propose other than Section 6, I don't know where one finds it. So I may have answered 5 of the questions wrong as to what he can propose, but I know that I've applied the right test because it's the only one in the Constitution.
Are we getting a feel, though, Mr. Schechtman, from what the purpose, I mean, I, too, have read Governor Smith's comment, what the entire purpose of this was?
We're not.
We've gotten pretty far afield.
We're not, Your Honor, because, again, we've gotten far afield because we're doing hypotheticals that have workers using cocaine on the job site. But we're not far afield when we go back to this budget. Because look what this budget said. This budget said so much for a homeless program for Agency A. Stricken. Single-purpose bill, so much for a homeless program to Agency B. Now, one of the things we know that was said by Governor Smith and by Henry Stimson is nothing is more important in terms of budgeting than knowing which agency can get the job done. Right? So it has to be that the governor can say to this agency. Now the question is, what can the legislature do in response? And Mr. Reese's response to that is what the legislature can do in response is put that budget on the shelf and write a whole series of single-purpose bills that the governor can veto. And there's the answer for Mr. Reese. The governor can veto. But if the governor can veto was an answer, then legislative budgeting is okay. Because in my example, right, in it comes the governor's budget. Up on the shelf it goes, and what we get are a whole set of single-purpose bills that he can veto. That's legislative budgeting. That is what happened in 1916, right? The convention in 1915. The Constitution was voted down, not because of executive budgeting, but voted down. 1916, Governor Whitman set up bills, and they were ignored. Well, if Mr. Reese is right, these are going to be ignored because you don't have you can't go in to the appropriation bill itself and tinker with it, but any condition that you don't like, you can take out in a non-appropriation bill, or any condition that you don't like, you can strike out the whole item, right, and put it into a single-purpose bill. Now, I may have failed you today in the sense of you gave me a set of tough hypotheticals that I think I had the governor at some point approving cocaine use on the job site. And
We understand that that's not his policy.
it's not. But please appreciate that there are hard cases at the margin, and they're not this budget bill. So, and I don't think there's any other question that this Court should ask other than the question that's put forth in Section 6. I think it has real teeth. I've tried to say that. I understand you can convert things in a wonderful fashion and come up with remarkable hypotheticals. But that's not this budget. And
Mr.
if I'm
Sheckman, once
sorry.
the budget passes,
Yes.
does the legislature have any options?
Yeah,
Can they pass separate appropriation bills?
Well, they can certainly pass separate appropriation bills for new purposes, or they can propose additional spending for the governor.
They can add to the existing budget
They
appropriation.
can add to additional appropriations, additional money, or they can add new activities. I think it's a word that the framers use.
They could widen criteria, eligibility criteria?
I don't think they can do, Your Honor. I don't think they can go back in after it's been passed in a new bill and change those appropriations in effect. You have an Attorney General case where they tried to do it in a subsequent appropriation bill. Now, the legislature's view is, it's an appropriation bill, you can't do it. But I think what's more important is it's subsequent and its purpose was to alter. What they can do afterwards, is pass general legislation. So if you were to say $500,000 for police cars, no video cameras, I take it what they can do in subsequent legislation is to say all police cars in the state have to have video cameras. That's general legislation. Now, whether you could use the money in that appropriation, I think that appropriation is still limited. But they can certainly go in and pass general legislation, even if it in some sense affects the appropriation. Those police cars now have to have video cameras.
They can't increase that appropriation?
They can increase that appropriation. They can always increase the appropriation. For $500,000, they can make it $750,000. What they can't do is in subsequent legislation, whether it is a non-appropriation bill, a subsequent appropriation bill, or some other piece of legislation, go in and change those conditions. Because if you can do that, the non-alteration clause has no life whatsoever. You can just do it through the back door, right? And you're right back to legislative budget. The governor's bill is on the shelf. Its purpose is simply the answer. Mr. Reese's answer is there is executive budget because he writes a budget. But what we know from Tremaine 2 is it is more than a mere source of information. And his view is stay up all night, write a mere source of information, and then we can change every one of those items as long as we do it indirectly. We can do what the Tremaine 2 legislature wanted to do as long as we're not foolish enough to do it in the appropriation bill. Right? And that sounds like a ready path right back to legislative budgeting.
Mr. Sheckman, I assume you would, we've established that you would draw the line at unconstitutional measures included within the appropriation. We've established that when we're dealing with gender discrimination, race, sex, and so forth. But I have, and then there, I think you part company apparently with Judge Malone, who said the governor can even put in unconstitutional measures, and the remedy of the legislature is to just say no.
Can't be right.
So we agree with that. All right, so let's put that aside. I have to tell you, I'm a little bit troubled, not necessarily conclusively, but would ask for some help with you on this. With your position in saying that the governor could include in an appropriations bill a repeal of Section 240 of the labor law or the minimum wage. And instinctively, I'm troubled because it sounds like to me like classic legislation, which under a separation of powers sounds very much like, on a visceral level, that's something the legislature should be doing. And so I was about to ask you whether we might word something to the effect that the governor can put in some policy determinations, can put in terms and conditions, but when getting into the area that looks like out-and-out legislation that we might be able to word something that way. But I don't know whether that's going to be possible, or whether you would concede that it is possible.
Judge, I've said before that as to some of the answers, whether it's your minimum wage hypothetical or Judge Smith's, I guess we abolished the drug laws, I'm not sure I'm right. It's hard to sort of stand up here and do it on your feet. And I understand what you're saying is, look, they just sound too much in substantive law, right? And
Okay.
I don't want to say to you, I know it when I hear it. I mean, as a judge, one has to have lines that, even if they aren't bright, at least have some shades of dark gray, right? And so, it may well be that someone more thoughtful than me about this can tell you why that minimum wage provision is general legislation, and even though it is limited just to the appropriation, right? In other words, only on this job, it still fails under Section 6. Again, I think that's the only source, that it is too much general legislation.
Sounds like it.
So,
doesn't
Mr.
it-
Schechtman, so it's clear that if what is proposed alongside an appropriation of an amount, $10 billion, whatever, is an amendment of legislation, that
Well, what I think I know, Your Honor, is that it can't be that the bright line is you can't notwithstand existing
so
legislation.
sometimes it could propose
Well,
amendments to the consolidated laws of the state of New York?
No, absolutely, Your Honor, but it can't
It could
be-
not?
No, I'm sorry. The mere fact that it notwithstands existing legislation isn't enough to say that it runs afoul of Section 6. Because my example of the sheriffs, where it's $40 in existing law and we notwithstand it to $34, right? I think that's an appropriation, right? We've just decided for this year we can't afford the 40. We're putting in the 34. We've been doing it for 12 years. I don't mean to argue.
Okay, so in that limited instance, you said you could see an amendment to the
The
law.
difference is numerical. Do you have an example where the difference is in words?
But then you take the next one, which is existing law says there is a program for student improvement grants. And it says in it, and the money shall be distributed equally across the state. And the governor says, we can't afford that. I don't have as much money to apply to that appropriation as last year. And so I want to target it better. So I'm going to go into existing law, and I'm going to target it to school districts that have reading problems. Right? It seems to me that has to be proper also. Whatever one's view of Section 6, that is related and limited. So I think what you can't do is say, just because you're notwithstanding existing law, aha, it runs afoul of Section 6, aha, it can't be an appropriation bill. Because I've just given you two examples. I won't take your silence as acquiescence, but they sound like things that should be in an appropriation bill. They sound like things that don't run afoul of Section 6. Now, having said that, when I hear Judge Rosenblatt say that I've just not withstood the WICS Act, or I've just not withstood the minimum wage law, right, and I hear myself saying, well, if it's limited to the appropriation, I'm not happy with my answer, and maybe I should just say no. My problem is I can't articulate the reason for
And
no.
yet we have to articulate some principle.
Certainly not in this case, Your Honor, because there are no strained hypotheticals in this case. Everything that's at stake here is like that star bill.
But we have to set out a principle for the future, Mr.
But the
Schechtman.
principle for the future is easy. The principle for the future is that there's one restraint on what can go into an appropriation bill, and that is the very powerful restraint of the anti-rider provision in Section 6. That's the only restraint, right? And there may be difficult cases, right, in order to apply it. Tremaine says there will always be difficult cases in this area. But that's the
So it
principle.
has to just come up on a case-by-case basis?
Well, I think over time, look, no governor has tried to get rid of the WICS law, the minimum wage law, and there's a reason for that, right? Which is to say that is political suicide. So the hard, or cocaine on the job site. So the hard hypotheticals here, you have the wonderful advantage, will never come before this court. What will come before the court is this budget, 1998
So it
budget.
sounds like you're saying, it sounds like you're edging toward, and you're very good with words, that that the result you're asking for would go something like, and you can correct me, while we affirm the appellate division and conclude that this budget is, that the governor's actions here were appropriate, we do not rule out circumstances which in the future, if the governor acts within the relevancy criterion and the bill and the appropriation is relevant within Article 6, it nonetheless may, under circumstances not before us, run afoul of his powers.
Judge, what I might say is that...
What do you think of that?
I think I take it because it has the word affirmance in it, so I should probably accept it, right?
And also the word relevant.
And it has the word relevant. But I think...
Leaving a space for, maybe not in this budget, but in some future action, which you say doesn't meet here, because frankly, I'm not worried about the governor going to abolish Section 240 of labor law. Those were, as you know, and he's not going to abolish the minimum wage either. We know that. But whether a rule can be formulated by which we examine this particular action and determine whether, although this one may be okay, there may be instances using your very test which can result in an actionable lawsuit by the legislature.
Yeah. And the reason I stopped you, Your Honor, was I do think the court ought to phrase it in the terms of the test that I stated. I think what Your Honor is saying is, look, that test, Mr. Schechtman, has more bite than you think it does. If the governor were crazy enough to really go in and fiddle with the WICS Acts and things that aren't related to dollar and eligibility criteria, don't expect this court to not say those are not limited in operation, those are not...
Even though they're relevant.
Even though they're relevant. It may be, or to use the second prong of that, if they're limited in its operation, I think the court can find the ability to say that you can't do. But what concerns me so much here is what's in this budget, which is to say AIDS program, right, to high-risk neighborhoods. The suggestion of the legislature is one house, you can't say high-risk neighborhood, right? That's too descriptive. The other house, you can say it, right? But we can take it out. We can't take it out in the appropriation bill, but if we walk over to a non-appropriation bill, right, we can take it out. And one thing I know is that if you allow that to happen, right, there isn't executive budgeting with a non-alteration clause, right? It is true he's a mere source of information, right? He's a good man. I think he will stay up at night and still prepare a mere source of information. But it is a mere source of information because there is nothing that they have to worry about in it. He can't force discussion on any issue. It can be tossed aside, right, easily discarded, I think is the word they use, the easy temptation. It can be tossed aside and they can start anew. And so what I ask you to do is to, excuse me if I got some of the hypotheticals wrong, but to say in this easy case, all of these are related to the operation, are related to the appropriation. All of these are limited in operation. They change eligibility criteria, right, and the like as to how this money will be spent, right? Therefore, they're appropriate to be in an appropriation. If they're in an appropriation, you can't take them out directly. And if you can't take them out directly, you can't take them out indirectly, because otherwise we're back to where we were in 1928. Right?
Thank you, Mr. Schechtman. Mr. Hancock?
Your Honors, if you look on page 14 of the Senate's brief, you'll see 6 amendments of state law attached to the governor's appropriation bills. The last one of that list, bottom of the page, changes the state education law, changing the state library and the state museum from the education department, the board of regents, to the Office of Cultural Resources. These are amendments of existing state laws. They were attached to the governor's appropriation bills. Allegedly, they would pass the anti-rider provision related to test. And if this court affirms, it is necessarily affirming the ability of the governor to attach amendments of state law to his appropriation bills, which the legislature is precluded from doing anything about under Section 4. I think the question
Now,
that...
you're talking about the item that's at pages at A164, 167, and A204, A209. Those are the cites in your brief, correct?
Yes.
And when I look at those pages, it's less obvious to me than it is when I look at your summary that this is not that this is amending legislation. I mean, it looks superficially like an appropriation. If you turn to 164, and it's got Office of Cultural Resources program. And it has an appropriation, and it says this appropriation shall only be available on submission of a plan formulated by the Office of Cultural Resources and approved by the Director of the Budget. But that's not quite the same as saying we hereby amend the education law to transfer the responsibilities.
But it effectively amends Education Law 232 and also 201, Parent 2, Your Honor. But what the point I would like to make is the questions which have been asked here repeatedly about what can be done under the anti-rider provision of Section 6, what can't be done, illustrate the difficulty of it, and they illustrate perfectly why the anti-rider provision doesn't apply at all and why it was never added in 1927, and it was never added until 1938. If it's the sole limitation on what can go in, it would have been added.
So you have a bright line. It seems to me you have a bright line test. It sounds to me that, and you're in agreement this far, that if the governor includes in an appropriation bill an unconstitutional provision, that's out.
Oh, yeah.
Clearly. Okay, go a little step farther, one step farther. The governor can put in some policy language. I assume you recognize that there's some degree of policy language, but you would draw the line, and it is a bright line, on an amendment of existing law.
Well, I go farther than that, Your Honor. I go to what is said in the Silver One brief as to what properly goes in a non-appropriation bill. Sources, sub-allocation, all of those things do not belong in an appropriation bill. They belong in non-appropriation bills where the legislature can amend them, and then the governor has a right to veto them. So,
but you wouldn't be satisfied. You wouldn't be satisfied with a rule that says anything goes up until unconstitutional or amending existing law. That's not
absolutely not.
Right.
Programmatic measures of the kind that are set forth in Silver One belong in non-appropriation bills. That's where they were put by the governor himself in 1998. The governor did it right in 1998.
What about the examples Mr. Schechtman kept giving us of where the state law says $40 a day, but you only appropriate 36, or state law says give money to every district, but the budget only gives it to some districts? Is that legitimate in an appropriation bill?
You're talking about
I should take them one at a time.
full aid.
Yeah, let me take the second one first. His example is there's a state law that says every town, every district in the country gets X kind of aid. I forget what it is. Every district in the state gets X kind of aid. And the governor says, we don't have enough money to do that, so I'm going to target it, thereby saying, notwithstanding existing state law, it gets targeted to certain districts. Can he do that in an appropriation bill?
I don't believe he can. I do not believe so. Because those would not be items of appropriation which can be added to or reduced or to which an item can be added. I really think the basis of this whole thing is really you go back to Tremaine 2 and Tremaine 1. And you go
Does it
down
have
a
to be
slippery
numerical?
slope.
Does it have to then be numerical? Is that the test?
No, I think Tremaine 2 says, you can identify the appropriation, what it's for, how much it is, who it's for, and that's what's supposed to be in there.
Suppose that identification contradicts something in existing state law. Can you still do it?
It's hard to conceive of how just saying the identification itself would would contradict state law.
Well, let me try. The state law says that that if you're going to have a program for the homeless, there must be one in each county of the state. The governor submits an appropriation bill listing appropriations, just names and numbers, but it doesn't have, but it's less than all the counties. Can he do that?
Well, we get back to the same, similar question you asked me before, whether that would be an itemization or not. It's close. You can appropriate an amount of money. I mean, the Tremaine 2 says the appropriation bill is supposed to be itemized. And in Tremaine 2, it was improper to delete the itemized appropriation given by the governor and replace it with a lump sum. That we know. So whether your hypothetical would be itemization that we're talking about, it's hard to say, Your Honor. But if it changes the law, amends the law, or if it includes the sort of thing which this court says should go in non-appropriation bills and Silver 1, that's improper because it can't work. Section 4 won't give the legislature any protection. All they can do is say, we don't like it. We don't want the state library change. We don't want it. And the governor says, okay, reject the whole thing.
Mr. Hancock, I think we've circled back to words I've heard before, so I'm going to call on Mr. Reese.
Thank you, Your
Thank
Honor.
you. You have 2 minutes, Mr. Reese.
Thank you. One answer to a very specific point by Mr. Schechtman. Other states do have a non-alteration clause. Maryland Constitution, Article 3, Section 52, Clause 6, Maryland has a non-alteration clause. Its governor does not have the power the governor seeks here.
How do we know that? Has the Maryland court decided that?
Well, Judge Smith, I can spend the time going through the Maryland decisions, but actually Maryland construes its line item veto clause quite narrowly, even in light of the non-alteration clause.
And that's a case, a Maryland case?
There are a series of them, Judge, if we can provide the court.
Well, we're not really asking about the line item veto. In Maryland, has the Maryland legislature established the right to do what you say the New York legislature can do, which is to amend appropriation bills by later non-appropriation bills?
Well, Maryland, Judge Smith, increases the governor's power in a way New York does not, because Maryland has a single-purpose requirement for all legislation. So it actually would prevent the introduction of a non-appropriation bill that has multiple subjects because it has a single-purpose requirement. It's critical. New York chose not to adopt that. It chose to limit the single-purpose requirement to appropriation bills. If you want to do what Mr. Schechtman wants to do, what the governor wants to do, the way you do that is with a single-purpose requirement that limits what the legislature can do, not just with appropriation bills, as Maryland has done, but with respect to all bills. New York's decision...
Is there a Maryland decision interpreting the alteration clause?
Judge Smith, in all honesty, I don't have it off the top of my head. I apologize for that. And that's fundamental, because that's how you legislate, you limit the legislature's power. Let me come back to first principles, and I apologize for going on. But the first principle is you look at what the Constitution says. Article 7, Section 4 says, the legislature may not alter an appropriation bill. It does not say, and Mr. Schechtman's entire argument is premised on this notion, it does not say the legislature shall not alter an item of appropriation. Mr. Schechtman's entire argument is premised on the fact that that's what the provision says, and it doesn't. It says, shall not alter an appropriation bill. And when the Constitution speaks to items of appropriation, it does so with incredible clarity, as it does in Article 4, Section 7. There is a reason why Article...
You would say that once it's enacted, it's no longer a bill, it's a statute, and then it can be altered.
Yes, Judge Smith, it can be altered in other legislation, and this Court has already recognized that. In Tremaine 2, this Court recognized there is a difference between an appropriation bill and the other legislation. And critically, It recognized that in 1939, which came on the heels of the 1938 change to the Constitution, which allowed the governor to submit other legislation according to Article 7, Section 3. So the fact is, when we look at the Constitution, we start with the language. The language does not support the governor's argument. In fact, the language completely refutes the governor's argument. Two words on what really are other critical separation of powers issues, and the Assembly has raised both justiciability and immunity. Frankly, we think those arguments are very straightforward. I don't know that there's any elaboration needed, but we do think, and this is a difficult case in some ways, that the governor clearly does not have standing to sue, as the senators in the Third Department found, to challenge legislation that he signed into law. We, in our opening brief, said that has never occurred in the history of this republic. And we don't see any citations in the governor's brief that it has. The reasons are simple. One, the executive doesn't have standing. Two, the legislature.
But another plaintiff could bring that suit.
Yes, maybe, yes. Absolutely, Judge Smith, but not the governor. He has a political remedy, which is his veto. And the reason why it's such a fundamental affront to the separation of powers, had he used his veto, he would have been held politically accountable. That's what the veto is for. What he wants to do is not use the veto, come to this court, and have this court shoulder the political accountability.
The governor can't, the governor can't make an unconstitutional bill constitutional by signing it. It would still be unconstitutional.
It would be were there a proper case in this court.
So you just have to find another plaintiff to get this court to say it was unconstitutional.
And there were in Tremaine 1, in Tremaine 2, and in Bankers. It happens all the time, Judge Smith. The second point is, and it's absolutely clear, under Article 3, Section 11, the Speech or Debate Clause, every legislator and the decisions are uniform, the legislative bodies are absolutely immune from suit. That's why there has never, again, in the history of this republic, been a suit directly against legislative bodies for passing legislation. And the governor's complaint puts this case in the sweet spot, the very heart of the bullseye of the Speech or Debate Clause. He sued the Assembly and the Senate for their actions in, quote, voting upon and passing legislation. I'd submit to this court, there is no more core activity than voting upon and passing legislation. If any action by a legislature is immune from suit, it's that action.
Thank you. Thank you, Mr. Yes, of course.
One more question. If we were to agree with you on standing and justiciability, we could still reach some of these issues in the other case.
Judge Park, absolutely. And in fact, the Silver case does present one of the three legislative responses that's at issue.
And that's the perfect segue to the Silver case. We will excuse Mr. Schechtman.
Can I get a word on this? Or I don't want to, you said you'd give us additional time. I don't.
Of course, you can.
Midnight.
I tell you, Mr. Schechtman, why don't you have one word on justiciability, and then we'll turn to Silver again.
I appreciate it greatly, Your Honor. Let me just say this. If you look at Tremaine 2, the only difference between this case and Tremaine 2, there's really two differences. One is that there, instead of signing the bills, the governor's pocket approved them. He simply let them become law. And for the life of me, I can't figure out why that should matter in terms of his standing. The second thing is the Attorney General agreed to bring the case. So the case was titled People. But we all know that for all practical purposes, that was governor versus legislature. The final thing to say is, as to the defendant, if we sued the controller, we did, and Judge Malone took him out of the action. If we'd sued him, I suppose he could have said, look, I agree with you. I think these are alterations, right? But the one thing I know is if we sued him and we didn't sue them, they would be here as amicus, right? Because this case is about the power of the two branches. And it seems to me
If Mr. Reese is right about the Speech and Debate Clause, I gather the Senate has not raised the same defense.
That's right, and I don't know of any...
So we have the same decision either way.
I think that's right, because I don't know of any privilege, any law that says one person's privilege is spill over. It seems to me the Senate has said it's essentially justiciable. I think they're right. Again, one last word, and then I thank the Court, and that is there's a reason you can't find the word non-appropriation in the language of that Article 4 provision. And that is because what they're doing is doing indirectly. If they were doing it directly, it would run into that language. They're doing it indirectly. Whenever you're doing something indirectly, you won't be able to point to specific language in the Constitution. But if you let them get away with it indirectly, there isn't executive budgeting anymore. I thank the Court
Thank you,
enormously.
Mr. Schiffman. Silver against Pataki. Mr. Reese?
Your Honor, might I have 2 minutes, if possible?
I'm sorry, what was...
Might I have 2 minutes just to take a break for once?
Oh, of course, yes.
Thank you.
Teacher, may I be excused is the question. We'll take a 2-minute break. We'll take a 5-minute break.